is intended for the personal, non-commercial use of its listener and may not be reproduced for any commercial purpose without the written permission of Rex Crandall and CALDA. The policies, positions, views and opinions expressed and/or provided herein are not those of the State Bar of California, CALDA, or any entity associated therewith, and are strictly those of the authors or speakers. No representations or guarantees of any kind are made with respect to the accuracy of the written, visual, oral or audio portions of this presentation, and nothing herein should be relied upon to answer any legal questions. The written, oral or visual information expressed or provided herein should not be relied upon in dealing with any specific legal matter. No attorney-client or CPA-client relationship is created by any part of this educational program and related activities. Attorneys, CPAs or LDAs using the information expressed and provided herein in dealing with a specific client or clients, and their own legal matters should also research original sources of authority.
Okay. So, Kathy, are you there?
I am. Can you see me?
Yeah. Oh, now I can. I had
Yeah.
my video off to the side.
Okay. Hi, good evening, everybody. I'm filling in, I guess, for Michelle wasn't able to be here with us tonight. This is our Unit 6 and our Unit 7. Well, Rex is Unit 6 and Unit 7 on our estate planning class that we've been having for the past few months. I hope everybody enjoys it. I think everybody knows Rex. He's a probate and estate planning attorney, and he's been with us for quite a while. So let's get started. Go ahead, Rex, it's up to you, and just give me instructions what you want me to do.
Okay, great. So during the presentation, we might want to save questions until the end unless they're absolutely crucial. The program should be an hour to hour and 15 minutes, I'm assuming, and then just an overview for everyone. We'll do maybe 10 minutes or so of questions after the technical material. And then we have a special guest tonight, myadvocate.com. It's an estate planning software platform for doing remote estate planning where clients could do that on their own without intervention. And I call that adult supervision, but that's not the right word. And then the software also does estate planning for individuals on consulting with a client or directly or with your family. So that's what we're going to have, and then we're going to have a question session after the video portion of the My Advocate. So before I get into the nitty-gritty of the detailed slides, I wanted to go over the class material because we have a lot of it. And I wanted to make sure that everybody understood what we were doing here. This is the class material on our Google Drive that you all should have a link to. And I wanted to point out some of the pieces of it. The book content is part of my book. It's the page on, I can't, got all kinds of reflection here, but basically it says comprehensive estate planning, don't leave Earth without it. You have the chapter on advanced healthcare directives. And then we're also have an assignment within the Nolo Press book. I have included for your use several advanced healthcare directives. And what I did is I accumulate, these are questionnaires that your clients can fill out, and then you can have them notarized or witnessed. And I included quite a few different types, so you can see which one feels best for you. This is a real nice one because it has a lot of pictures and explanations, and it's not intimidating by anyone or to anyone. And then we have this other one that's for caring info, and it has some introductions. It came from hospice. instructions and things to help filling it out. And then we get into the Advanced Healthcare Directive portion, and this is all fillable. And this is more in the statutory form, and it gives you choices. It ends up being a discussion when we start getting into the Advanced Healthcare Directive of what the person's feelings are about various aspects of things that may take place. Then the next one, these are all in one big file. I have used this one many times. This Advanced Healthcare Directive is put together by Kaiser, and it's fairly thorough, easy to use, set up, and I've made the forms fillable for you if you want to use the Kaiser form. And then the next one, this one's a little bit different angle. This is federal. This is the Veterans Administration. And it has a little different slant on how to put things together, initials and boxes. You just have to look. I'm just trying to give you an overview. I'm not trying to teach these forms to you right now. My purpose is just to tell you what resources are available to you.
Rex, excuse me real quick.
Sure.
Your screen share is not working yet?
I was just gonna tell him,
Okay, thank you.
Yeah.
Let me see. I lost my controls on Zoom. I had a control box while we were setting up. Okay, here we go. Screen share, share sound. I don't know why all these things are coming unwound, but that's okay. Is that
there you
better?
go.
Do you see my screen?
Yes,
Okay, now I lost my video.
we can see you.
I can't see me, so I can't tell if I look like a dork or what, but
You look great, don't worry.
I don't know where I went, but I'm in there somewhere. Okay,
We can see you, you're fine.
okay, that's fine. I just like reassuring this, get a video of me so I can really be assured I'm breathing. Okay, so the next image that I had taken a lot of time and made wallet cards. Let me get this readable. Wallet cards that your family and friends can use these to alert people that there may be an Advanced Healthcare Directive. There's another method also. And this is the form that we'll discuss further, but you can register your Advanced Healthcare Directive with the state of California, and this file is available to all emergency medical personnel. And that's something fairly new to me that I didn't know about in the past. So I'm still going to show materials. We've gone through this one. Okay, we have the required homework cover sheet with the multiple choice questions and the homework assignments that you have to turn in. And then I've included the slide deck that we're going to be going through. The next form in your student materials is the DNA form. Do not resuscitate. So you have one to be able to use, and it is fillable, and we'll get into the detail about how it works a bit later, but it's ready for use. And then I've included a pulsed form that physician's order for life-sustaining treatment. It's generally for someone on the last year of their life, and we'll get into the details. All I'm saying at this point is you have the form, and we're going to cover the details. It's supposed to be on this bright pink color on your refrigerator, but we'll get into the details. So that is available for you. The multiple choice questions. And then the other thing I wanted to point out is most of these classes have a video And then we go through the slides, I explain the material. And then there's multiple choice and you turn in homework. There's one section of this program that is not really supported by a lengthy video. There is a short video here on probate. We call it unit number 7, but there's no scheduled date on the calendar where we're going to be covering that. This is entirely home study. So I pointed out, you need to look at this in your material. There's the book content on probate, the multiple choice. And here are the legal forms that you will need to fill out to turn in for your homework with hypothetical example. And then we gathered, most government forms do not have instructions. Like an IRS 1040, you go right to the instructions. The judicial council forms don't have instructions. So we pulled together some background material for your use to support your filling out of these probate forms. And this is not a class on probate, but I wanted everyone to get an idea of what it is, kind of an overview. And these forms that are part of the homework, are the forms that you would fill out to start a probate. Okay. So we got that taken care of. Now, let me find these materials. Okay. There we go. Okay. So what are our learning objectives for tonight? We're going to learn what an Advance Healthcare Directive is, what happens if you have a healthcare directive and you become incapacitated, what is a healthcare agent or proxy, what are the risks to your assets or beneficiaries for having one or not having one, how does it work in real life, which this particular thing works differently because it has to do with the medical community. Who should you name for your healthcare agent? And what are some common end-of-life decisions that should be considered as part of your comprehensive estate plan? So in Advance Healthcare Directive, you're making decisions about healthcare you want to receive. And oftentimes it's from a medical crisis. It doesn't have to be. And the decisions you make and write out give your agent more guidance, so they don't have to make the decision based on their values. They're making the decisions based on your values. And I want to make when we do the Advanced Healthcare Directives in our office for estate planning clients, we always make the document effective on signing. So what we just created, we have 2 people now that have authority to make medical decisions. And I don't see that as a problem. As long as the principal is still competent and talking with the doctors, there's no problem. If the person becomes incapacitated, brain injury or something, you've already got that Advanced Healthcare Directive set up. And it says what kind of treatments you want. It's in writing. And the idea that you want to do with the Advanced Healthcare Directive is to also give permission to medical providers that it's okay to talk to a third party about your medical condition, because they're very reticent to do that. So on the form, you'll be appointing an agent. And anytime we do anything with a trust, a will, or any legal document, we appoint usually the principal and then 1 agent and then 2 more agents or sub-trustees. I don't like going to court anymore with the trusts and documents where they have one person's identified, that person's unable or unwilling to serve, and then we got to go to court to get the judge to approve another person. Appoint 3. That's the safest way to do. So you want to pick somebody who will advocate for you in a situation where you're unable to make your own decisions. and you just express what kind of surgical procedures, CPR, organ donation that we'll get into in a bit more detail. What happens if you do not have an advanced healthcare directive and you become incapacitated? The medical community doesn't really have anyone to make decisions for you. They have kind of an internal hierarchy of people that they end up having to talk to, even though it's kind of risky for them because they're on HIPAA laws. But if there's a standoff like the Schreiber case a few years ago, a gal was comatose for years, and there was litigation back and forth in the state of Florida and US Supreme Court. And it was basically the question of pull the plug or don't pull the plug. And you can take care of that in the Advanced Healthcare Directive, but if you don't have one, then you'll need to file a conservatorship case with the Superior Court to have a judge appoint someone who can make these decisions for you. And it's less cost for the family if you have an Advanced Healthcare Directive rather than starting a court case with continuous court supervision. So HIPAA is a big deal to the medical community. It came in '96, and there's significant penalties if the healthcare providers give out your medical information to a third party. If you have adult children, let's say they're away at college, they're over 18. If anything happens to them, even as a parent, you're not authorized to get their medical records. So we recommend getting an Advanced Healthcare Directive for all your adult children also, that includes the wording for the HIPAA, Health Insurance Portability Act. They can be two separate forms when we prepare them, the Advanced Healthcare Directive and the HIPAA waivers built into the one form. Okay, so oftentimes people will make the Advanced Healthcare Directive subject to being named, diagnosed with a incapacity. I wouldn't do that. A lot of people have. It's not worth it to me. It just seems like if you have the Advanced Healthcare Directive, let it operate, and usually the agent's not going to step in front of you and make decisions you don't want. If you do not have an Advanced Healthcare Directive and you become incapacitated, you might end up going to court for a conservatorship. There's two types under California Probate Code. One is a conservator of the person, so that would be housing, food, recreation, medical, transportation, all that types of activities. And then the other is a conservatorship of the estate. And that relates to paying bills, in charge of investment accounts, things of that nature. And a person going for a conservatorship for a loved one, they can either go for the conservator of the person or the estate, or both. Doctors have quite a few civil penalties if they give out information. I saw a documentary where this guy in Florida was getting ready to start his prison term, and he would go outside dentist's office, pay him monies, the employees going there, so that the employees would give him the confidential information, and then he would turn around. He was filing like 30 tax returns a day and getting huge false tax refunds, and got convicted for it. These are the top level fines that medical personnel can get if they release personal medical information, and it's high enough to scare most doctors into compliance. So when you create an Advanced Healthcare Directive, verify that it has a HIPAA release that allows doctors to get your medical records too, not just to make decisions. Some people will give a HIPAA release form to a third party. By itself, it does not allow them to make medical decisions. So it's not that useful. This is an example of a form that is in your student material, and this one is quite easy to use. This is another view. I mentioned that when you have an Advanced Healthcare Directive, you can put these kind of notifications in your wallet or your purse and let medical personnel know. There's a better way, which I'll show you in another slide, on getting a bracelet. There's a procedure with the state of California. You can take your Advanced Healthcare Directive and you register it with the state of California. And I have fillable forms in there for you to do this. And you'd say, well, why do you want to do that? Well, the reason is it goes in on a database that you have an Advanced Healthcare Directive. So, for example, if you're halfway between Truckee and Reno, and your car flips over and you're in a down in the river, and medical personnel, before they get there, if they know your name, they can bring up that you have an Advanced Healthcare Directive, and that facilitates things in certain circumstances. This is an interesting twist. I have heard people talk about godparents, godchildren, and what does it really mean? So I looked it up. Well, it turns out that when you agree to be a godparent for a child, usually at baptism, under the religious doctrine of Christianity, it means that you are agreeing to continue the religious training for that child if the parent doesn't. It has nothing to do with care and custody, which I find that most people, including myself, would use a definition that says, you're going to godparent, that means you're going to take care of the child. But times have changed. This was maybe worked very functionally 2,000 years ago, but things have gotten a little bit more complicated. And at this stage of the world development, a godparent is not an enforceable agreement. So in the example, you really want to do this for your family member or friend that you want to be the godparent. So what happens, let's say that both parents die in a car accident and the kid is injured too, the child is in the hospital, and you're the godparent, you can't make medical decisions for the child. They cannot give you medical information. So the parents need to give you an Advanced Healthcare Directive in order for that to work in that particular circumstance. And what happens when both parents are deceased and the godparent steps up and says, I want to raise the child? Well, you're not following any procedure. And the way that parents of minor children identify people to be guardians is you need to put the guardian nomination in your will. And then the judges will usually honor that. The interesting thing about Advanced Healthcare Directives that I didn't realize is on the other side of these documents are all these medical facilities. I mean, I've been to doctors' talks and nurses training classes to get nurses licensed, all on Advanced Healthcare Directive. Clinical social workers, the medical community is the other side of all these documents. And these errors came from an intake nurse at a large hospital because this is how they invalidate them. And if you make one of these errors, your Advanced Healthcare Directive is void. So the principal doesn't sign the form personally. Sometimes nobody's around, the family member will sign because the principal is unconscious. You cannot have medical staff witness the Advanced Healthcare Directive. If you're in a skilled nursing facility, there's a person overseeing that facility called an ombudsman. That's easy for you to say. If the ombudsman doesn't sign the Advanced Healthcare Directive and they're in a nursing facility like this, it's void. Healthcare agents cannot, the agent themselves cannot sign as one of the two witnesses. Either on an Advanced Healthcare Directive, you can use two witnesses or one notary. We usually use one notary, but if you're in intensive care unit, you might need witnesses instead. Another problem is naming two agents at the same time. You don't want two agents. You don't want two trustees at the same time. You don't want two executors at the same time. They all must agree in harmony, and that may not happen. Not picking the best healthcare agent, someone who is maybe real gullible or doesn't have a lot of determination not to follow your rules, not their rules. Another problem on the Advanced Healthcare Directive is not being detailed enough. You got to give some guidance to your agent. And people make mistakes like, I don't want any resuscitation. Well, that may not be really what you mean. Do you mean no CPR? Do you mean no incubation? No feeding intravenously? I mean, a lot of the words that we take for granted, the medical community does not. So that's vague and over-inclusive wording. And the biggest error of them all, and most common error on Advanced Healthcare Directives, is not having one. I've talked to a lot of people. Yeah, we're going to get to it. Yeah, we thought about it. We're pretty soon. That is the biggest error. Now, this other idea I got from Carrie Rowan at the law library, and I just love this idea. So you're the agent of a senior, let's say your grandmother or a senior mother or something, she's 95, and you are helping going back and forth to doctors and everything else. What this idea is you create a healthcare binder and you're the agent. So you put in there details about medical visits. You put in medications. You put in a copy of your Advanced Healthcare Directive and other documents. And so in an emergency, the ambulance is taking your mother to the hospital. You grab this on your way out of your house, and immediately for the emergency care, you can tell them, these are the prescriptions that are being taken. This was the diagnosis of this other doctor. And the woman that told me about this method said it was invaluable in helping and getting emergency care for her mother. So I think that's a wonderful idea to consider. Do not resuscitate. So we're not talking about Advanced Healthcare Directives anymore. We changed forms. Now this one is do not resuscitate. So the assumption here is you're not in the hospital yet. You're out somewhere and you keel over and you need CPR or some other kind of care. And this form says, I don't want it. But emergency medical personnel have to know that. So there needs to be some way to explain it to them. And this form is basically a first step. I've given you a link to where to get additional forms. And I told you about the wallet identification for the Advanced Healthcare. You can also use these for the do not resuscitate. But there are several companies that create these wrist medallions. And I recommend that if you have a do not resuscitate order, that you get one so that your wishes are followed. They also sell these military style dog tags that can alert personnel. This one woman in England was protesting because of not following the do not resuscitate. And so she tattooed it to her chest. Well, I hope she doesn't wear a turtleneck if she needs resuscitation. And the real fallback of that method, I think, is if What if you change your mind? You've got some surgery to do. But one situation that came up last year was we know someone who was had a do not resuscitate order. They went to a hospital that wasn't their normal hospital. They collapsed and had heart failure in the reception area. Medical personnel did CPR and resuscitated the person, and they are alive today and happy about it. Had the medical personnel known that they had a do not resuscitate order, they would have died in the reception area. So when these forms are for sale from the state and these nonprofits, one copy goes to retained by the patient, another copy goes to a doctor. A doctor has to sign a do not resuscitate order for it to be valid. And this is one place where you can get the forms. The forms are less than $2 per packet, or people will oftentimes just use the blank forms. So it recites what you're giving up. You don't want CPR. You don't want emergency medical, hastening your death. You don't want those electric paddles. My cousin in Clear Lake had that twice in 1 year, and he said, I don't want those anymore. Just forget it next time. Just let me die. So the physician needs to sign it in order for it to be valid. And for this form, you can have the physician or the physician's staff sign to make this form valid. One thing that a lot of people are not aware of, they when you see CPR on TV, the person gets resuscitated. 10 minutes later, they're bouncing down the street and everything's fine and dandy. Well, in reality, CPR only saves less than 10% of the lives that are attempted, which is way less than I thought. Another factor is that may be part of your decision on a do not resuscitate order is that ribs are always broken or frequently broken. You have to compress the chest 1.5 inches. And this is an example of where all the ribs break. So if you're 95 years old or your loved one, maybe they don't want to get resuscitated and live the rest of their life with broken ribs. Something to consider. We're changing forms again. This is a new form called the Physician's Order for Life-Sustaining Treatment. And this particular form is for seriously ill people that are expected not to survive for a year. So they have really a weak situation with not a long-term prognosis. And this form, it's a standard form, which I'll show you here, needs to be signed and dated either by a doctor or a nurse practitioner or a physician's assistant. And each of those caregivers have an ID number that needs to go on the form. And you can get the forms at Coalition for Compassionate Care is one place. And it's recommended that you put this on this bright pink paper in your house and you put it on your refrigerator. So when emergency medical team comes in to revive you on an emergency call, they look at the refrigerator and say, oh, we got physician's order here. So that's one way to do it, in addition to perhaps a medallion. I really wouldn't recommend the tattoo method. A little too expensive. So the physician's order for life-sustaining treatment is a form that the patient fills out. They say, well, I want full treatment, I want selective treatment, comfort focused treatment, whatever the patient wants. And as part of that, they go into the details of artificially administered nutrition. And then the signatures of the patient, and I think the state of California thinks everybody's stupid that you have to have a doctor sign to make your own medical decisions. It's called in locus parentis, where the government is stepping in for your parents. But this form to be valid, it has to be signed by a doctor, nurse practitioner, or nurse's assistant. And then after the forms, you're not done. You get the pulse filled out, give it to your medical provider, your HMO and others. This is a list of 3 of the providers who can create that wrist bracelet describing your medical choices. Here's more contact information to locate the forms. And this is a ludicrous view of the world, and it's my own view. If I'm on life support and they run out of chocolate, just pull the plug. It's not worth it. And then the reboot computer method, I thought was rather humorous when I first saw it. Okay, now we're in the California End of Life Option Act. And what we're talking about here is somebody's terminally ill. They've got less than 6 months prognosis to live, and they want to take an aid in dying drug. And California allows it. Several years ago, you recall about Dr. Kevorkian, and he was assisted suicide. Was it murder? Was it manslaughter? All these things related to it. California adopted the rule and as a series of requirements that the person has to be competent and ask for the aid in dying drug themselves. And the doctor does not have to participate if they don't want, and they do not have to refer you to a third party. But let me explain what you have to do to get this aid in dying drug. They make a bunch of hurdles for the person asking for this. First, they got to ask verbally. They have to wait 15 days. They have to ask verbally again after 15 days. Well, you probably don't have an appointment, and it's hard to get doctors on the phone after 15 days without another appointment. And after you do those 2 verbal requests, you have to give the doctor a written request for an aid in dying drug. And then the doctor has to get, the doctor himself, no agents, has to get all these 3 requests, and then the doctor has to bring in another doctor to confirm the diagnosis of the short-term life prognosis. And then you can have an aid in dying drug, and the law says you cannot take it in a public place. Well, I was thinking that through, and I figured out, how in the heck are they going to stop that from happening? You know, somebody wants to take it in front of the IRS or in a shopping center. What's going to stop them? Anyway, it is a possibility in certain circumstances. So life-sustaining treatment, there are several of them, and I was unfamiliar with all the different types. CPR is just the tip of the iceberg. There's lung, kidney, dialysis, food, blood, medication, transfusion, mechanical ventilation, hemodialysis, which I have no idea what it is, ventricular assisted devices. So you need to specify if you want or do not want some of the life-sustaining treatment. Can I donate my organ parts after my death? Yes. If you're 18 years old, sound mind, you can donate your parts called anatomical gifts. We have a ludicrous celebrity program that we work with people, and this client in recently goes, I don't even know if I have an anatomical. I went all the way through 6th grade, and where's my anatomical? So I had to tell him, okay, Mr. Foxworthy, the word comes from anatomy, and you're donating body parts. Oh, okay, so it's anatomy. And there's a lot of requirements about anatomical gifts. one way to handle the situation, if you want to be a donor and help out other people, is to register in the Donate Life California Organ and Tissue Donor Registration Internet website. Whew, easy for you to say. So it's a good cause, and we always have a shortage of donated organs. I flew airplanes for 25 years, and I would see airplanes, small airplanes, come down, and they'd have an ice box, and they were taking it from one airplane and putting it in a car, and those were frozen organs that they were translating, like kidneys and other body parts. Penal code, crimes. I was in a South American country a few years back, and I heard a story that was told about a guy who went to a bar. He was having drinks and meeting people and enjoying himself. And the next thing he knew, he woke up in a building, and he had his retinas removed. He had taken a Mickey or something in the bar, and it was illegal organ donation, and horrible. And about 40, 50 years ago in Spain, Madrid, they had a problem over there where doctors were delivering babies and saying the child was stillborn, and then turning around and selling the baby into adoption. And right now there's a lot of people in Spain who are trying to recover their roots. Funerals in the US have changed quite a bit since the 1800s. And there's a process called a wake, where people would stay with the decedent for a day or two to make sure they didn't wake up. And they would have funerals in-house. They didn't, before 1910, there were no funeral homes. And they would display the body, have a lot of people over, they would promote services, and the people would stay there and drink and play games and things, and helping to relieve their distress and grief. And then after 1910, we got funeral parlor businesses, and that room in the house that used to be called a parlor is now called a living room. Part of doing an estate plan should be including your end of life decision on what to do with your remains. So it's something you want to plan, because I don't think it's fair to your survivors that they have to pick out a casket or other procedures, cremation, and it just makes it easier on your survivors if you take care of that yourself. Burial is still most popular, but cremation is becoming an increasing choice for people. Donation to science, natural burial, burial at sea, scatter ashes, there's requirements. And then we have one client who prides himself on being the cheapest guy in the world. So we got a program for him now. So he can donate his body to science, and it doesn't cost anything. There's no burial, there's no cremation. They take care of it, and the body's donated to science, and it works for some people. And these are agencies, research facilities that will accept whole body donations. Other choices, what do you call it? Alkaline hydrolysis. They're using lye to break down the body parts, water cremation. And this one is recent in California. We just got a law within the last month on human composting. I think it's sick, but okay. And the way it works is they put somebody in a tray, and then they put them in a composting area for so many weeks, and I don't know the exact process. One thing on the internet said they did it out of state of Washington for $7,000. But yeah, there's some bad side effects there. Especially like the joke I heard about it was that it gives new meaning to grandma's vegetable soup. or don't stand on that garden. My aunt's buried there, sick. Cryogenically frozen, under the belief that they'll find a cure and fix your medical problem. Cryogenics. This one's one of my favorites. It's plasticization, which is not easy to say. I've been to 2 of these events and exhibits, I should say, and my gosh, are they educational. I've seen lungs, that smoker lung and a non-smoker lung, and you can see the difference. And membranes, muscles, parts, unbelievable educational experience. This Tech Interactive is still has an exhibit like this that you can attend now. And then I was kidding my daughter. I was saying, you know, when I die, I'm going to get plasticized like this, and I'm going to be out on your front lawn as an ornament. But for some reason, she didn't think that was a good idea. I don't know. The other thing is pick out urns and just to make it easier for your family. There's a lot of variety, and you don't have to do everything that like everybody else does. Neptune Society, flying airplanes. I'd see Neptune coming out, going to do scatter ashes at sea or over the bay. And this is another one I thought was interesting. Houdini, when he died, he said, I'm going to come back if it's possible. And if anybody could have done it, Houdini could have. But we haven't heard from him lately, so I guess the round trip ticket is not that much possibility. So you basically, the way I look at it, you set up your estate plan, and you then time goes by. It's kind of like being blasted off in space, and you see how the plan works out in the future. Summary in conclusion, designate a healthcare agent. It would be helpful to you and your family. Get a HIPAA waiver. If you want to do not resuscitate order, and planning out helps your beneficiaries. And my motto is have a blast while you last. And that is the overall Advanced Healthcare Directive class. So I'd like to open up to see what we have in the area of questions. Do we have any questions?
Hi, Rex. There aren't any questions in the Q&A, and I think the chat is mainly people talking back and forth to each other. Did you want to go ahead and have Mr. Wolfs present his program, or?
Yes.
Okay,
That's fine.
I'm going to make him a co-host,
Sure.
and then he'll be able to
Let me locate that material. This one, I hope this is the right one. I had 2 and one did not have enough volume. And so what I'm explaining to everybody what we have here. This is a vendor that is a vendor of ours. We work with My Advocate, and they have a software package that does a couple of very interesting things. One is clients or potential clients can go do an estate plan on their own without your help. And then another side of it is you can help yourself, family members, and others create an estate plan, and they have the software capability to make that happen. And we're going to, we are working with My Advocate in terms of the remote preparation of estate plans. And I wanted to make this information available, and have LDAs and others aware of what the possibilities are. And with that, I am going to start and invite in Rudy Wolf and his presentation. And after this 10 minutes, then we'll see if there are any questions.
Yeah, there are some coming in, so whenever,
Are they questions for me or on this My Advocate?
for you,
Okay, let me hold off for a second on My Advocate.
okay,
Let me address the questions from Advance Healthcare Directive.
okay. Somebody wants to buy your book?
Okay, to buy the book, you do a search on Chrome or any other browser, and you go Rex Crandall and then the word Amazon, and it'll bring you right to the page where it's being sold on Amazon. It's available in paperback and it's available in Kindle versions. So that's
Yeah,
where we get.
I got it on Amazon.
Right. I remember you were one of the first ones as soon as it came out. Boy, Kathy Herzog was right on that, got that book. Yeah,
I know you needed that money, Rex.
I know. Yeah. And she was showing everybody in the neighborhood. That was great. I like that. So
Somebody has, they have, so Lisa, I have a question on the HIPAA language. So I'm not sure what her question is. She didn't
Okay.
write it.
So what we're talking about on HIPAA language is what you want the doctors to know is that you have given your authority to let your personal medical information be given over to your agent. And there are standard forms, and in those standard forms, I gave you about 4 or 5 of them in the class material. There are HIPAA waivers built into them. So you can write your own, but why bother? They're standard, and it's not any magic wording. You're just giving permission to your doctors to give out your info.
So that's all the questions for now. So why don't we go ahead with Mr. Wolf's?
Yeah, sure. Yeah,
Okay.
myadvocate.com. And as I mentioned, they're a trusted vendor of ours. And it's quite interesting seeing what they have here. And this video is also available in your student material should you want to look at it later. So let's get started with My Advocate information.
Thank you to the law offices of Rex Crandall for the opportunity to present. I'm going to give a short presentation and demo on how LDAs can leverage our advisor platform to coordinate the estate planning process with clients to generate legal documents and an overall awesome estate planning experience. I started My Advocate in response to being an executor of a close friend's estate, and every bad thing that could happen did. During my time as Chief Technology Officer at ING Direct, and then as Chief Information Officer at Capital One, I spent my whole career helping simplify complicated financial solutions. I wanted to take this experience to simplifying estate planning. I partnered with Paul Rabelais. Many of you have seen Paul on YouTube. He has spent his career educating and helping Americans build better estate plans. We are named My Advocate for a reason. While every American has a different comfort level with technology or has different estate planning needs and complexities and concerns, one thing remains the same. They need an advocate. My Advocate has built a platform for LDAs to be their clients' advocates by helping them build and maintain the estate plan. The My Advocate Advisor solution is an end-to-end estate planning solution empowering LDAs to lead the engagement with the client, confidently generate estate planning documents and diagrams, securely manage their client's information, and then maintain an active ongoing relationship. You control your client's access to the estate plan data. At the end of the engagement, you can hand over the credentials to your client if you prefer, providing them with access to their own estate planning portal. Some of the key benefits are the option to have a branded dashboard for your clients, re-engage clients when they have new estate planning needs, provide your clients with the ability to notify and educate their executors, trustees, agents, beneficiaries of their roles, as well as potentially even share the documents with them. We have 2 primary products, the Custom Will Plan and the Living Trust Plan. Custom Will Plan is a comprehensive will package that covers all forms, and you'll see that later of the capabilities. The living trust plan is the custom will plan with all the provisions needed to convert that into a living trust. We do offer two options for document generation. One is we provide real-time, within minutes, the PDFs that you can print and sign immediately, or you can order a binder with the pages printed and tabs on there. We do have some products coming out in early 2023, a gift trust and a retirement distribution trust. Now for a quick demo of how the product works.
Hi, I'm Paul Rabelais, Chief Estate Planning Officer at MyAdvocate. In this video, I'll give you a demonstration of the MyAdvocate's self-directed online estate planning platform. During your assessment, you'll answer some big picture questions so that the platform can, 1, help you determine whether a will plan or a trust plan is the best fit for you, and 2, determine your most important estate planning objectives so the platform can focus on those matters as you build your estate plan. In advance of this demonstration, in order to save time, we completed an estate plan for a hypothetical couple, Vanessa and Isaac Morgan, and now we're going to go through that with you. Here, Vanessa entered her name and contact information. Here, the contact information for Vanessa's spouse, Isaac Morgan, was entered. And here, the information for the 3 children was entered. At the end of each section, a diagram pops up, which makes it easy for the user to review the information that was entered during that section of the estate planning creation process. At this point, the user gets asked questions regarding how they want to leave their estate when they pass away. This question asks the user whether they want to make any specific distributions of assets when they pass away. Note that on the left-hand side of the screen, there is both video and text help to guide the user, if necessary, through the question and answers. And here is the summary diagram of Vanessa's $10,000 specific distributions to each of her grandchildren. After any specific distributions are addressed, Vanessa gets asked how she wants to leave the remainder of her estate to her spouse. In this matter, Vanessa selected that she would leave the remainder of her portion of the estate in trust for Isaac. And then after Isaac dies, to beneficiaries that she will designate. Again, note the help on the left side of the screen. Here, Vanessa selects.
What happened?
Did you turn it off, Rex?
I didn't touch anything.
Okay. It's a little blurry too. Were you playing it?
Yes, I don't have control over the blurriness. That's on the document itself.
Rex, try the little gear. See the little gear there?
Yeah.
Picture the gear. Go there and see if you can set. You set the quality higher if you can.
Quality to 360.
Yeah, that's still not very good though.
Okay. I don't know what happened to our internet.
Well, did you say that, I thought you said earlier that participants could watch it again somewhere?
Yes, it is in our class material. And okay, so Advance Healthcare Directive. So we go here to, let me see what I can do. I want to reconstruct this here.
Is
Planning
it
creation
possible?
process.
Okay.
Sure.
At this point, the user gets asked questions regarding how they want to leave their estate when they pass away.
Okay. I brought up the one from the class material. I'm going to close out the one that's having a hiccup, and I'm going to try to locate where we were in the video so that we can continue. It was, I believe it was somewhere in here.
To guide the user, if necessary, through the question and answers.
Oh, man. Okay.
And here is the summary diagram of Vanessa's $10,000 specific distributions to each
It's much
of her grandchildren.
clearer, too.
Yes.
After any specific distributions are addressed, Vanessa gets asked how she wants to leave the remainder of her estate to her spouse. In this matter, Vanessa selected that she would leave the remainder of her portion of the estate in trust for Isaac. And then after Isaac dies, to beneficiaries that she will designate. Again, note the help on the left side of the screen. Here, Vanessa selects that after she passes away, her estate assets will be placed in a trust. Isaac will receive the income from those assets for life, and he may also receive principal distributions for his health, education, maintenance, and support. Next, Vanessa is guided through the process of selecting an initial and alternate trustees of this trust for Isaac. Next, Vanessa is asked who will receive these trust assets after both she and Isaac pass away. Here, she selects that different beneficiaries will inherit in different percentages. She can also select whether those beneficiaries will inherit either outright or in a trust that would continue after Vanessa and Isaac both pass away. If the user selects that a beneficiary's inheritance should remain in trust, note that there are many different distribution options available to the user regarding how and when that beneficiary will receive their share. Here, instead of Isaac having to answer the same questions all over again, it is selected that Isaac will leave his portion of the estate the same way for Vanessa and their beneficiaries. Here's where they each select who will be the executor of their will and the successor trustee of their living trust. They each selected their spouse first and then alternates to serve in that capacity after they both pass away. In addition, they can select from other estate planning options, including providing a no contest clause and granting others powers over digital assets. Here's where they will select their agent on their general durable power of attorney, and they will also select who they would want making medical decisions for them if they are incapacitated on their healthcare estate documents. Here's the plan summary page where each spouse can view the helpful summary diagrams to view the customized decisions that they made as part of the estate planning creation process. Next, the user will be walked through the process of viewing and printing their estate documents, signing their documents in the presence of the appropriate notary and witnesses, uploading scanned documents along with documenting where originals are located, and optionally notifying and educating those who will play a role in the estate plan. Here is a view of page 1 of a last will and testament, page 1 of a living trust, and page 1 of a sample general durable power of attorney. And finally, here's another view of the 10 different supporting diagrams showing the particular and customized decisions that the user made when they built their estate plan.
Hello, everyone. My name is Jack. I'm the third co-founder at My Advocate, and I lead our operations. Thanks so much for watching. Because of our association with the law offices of Rex Crandall, and because we're excited to work with you, we've decided to give everyone enrolled in the course an amazing discount. This includes free access to our professional advisor platform, which is typically $99 a month, 40% off all plans you purchase in the first year, 30% off all plans purchased in the following year, premium support for you and your clients, and a 20% commission on everyone you refer to My Advocate but don't take on as a client. This promotion is limited to those who sign up over the next few weeks. It doesn't cost anything to get started, so we hope you'll take advantage of it. To learn more and get started, email us at support@myadvocate.com and let us know you're enrolled in the course. Thanks again for your time.
Okay, so I wanted to make a comment that you may have seen on the documents that there was a QR code. And that was a unique feature of My Advocate. When you scan in the QR code, you're brought to a web link, and it tells the person that the documents have not been amended or revised. So it's an assurance feature, so, which is unique. I've never seen it on any other state planning. And I also like the flow diagrams and charts. I think those are very useful for people to be able to visualize what they're doing, instead of what we normally have is just a stack of papers that they have to digest. So I think the graphics are quite helpful. At this time, I would like to see if there are any student questions about My Advocate.
I don't know if there's any questions. I'm going to go into the Q&A because we have a few more here. So let me go to where. Okay, somebody asked that. I got my. Do I need permission from doctor to revoke? I'm not sure. Borky Jordan asked, do I need a permission from doctors to revoke? But I'm not sure what they're talking about.
Sure,
As far as
I'll take the question. So we talked about several documents today, and one of which is the Advance Healthcare Directive. No permission is needed for the doctors to officiate over it, and you can revoke it and amend it. Then we get into the DNR, which a doctor has to sign, and to revoke that, you have the full ability to revoke, and the doctor does not have to approve your decision. Now, on the post, that's another of the documents that needs to have a doctor's signature in order for it to be valid. And no, there's no requirement to make them void. One thing that is recommended for void documents or changed documents is you put a line through the old document, write void and the date, and then you do a new document on top that replaces it. So any provider that has that will know this is the right one. And when you revoke or change a document, you need to recall, I gave it to this doctor, this health plan, and you need to update it with the places where the document went.
okay, there's a couple of questions from My Advocate. They want to know how do they get paid and how much while using it? Can you use it for out-of-state business?
Can we take those one at a time, please?
Sure. How does a,
So-
if an LD?
Yeah,
Somebody
great
wanna-
question on how do you get paid. So my name is Rudy Wolf. So I was in the initial part of the
Okay,
video.
hi, Rudy.
Hi there. Happy to answer some questions, and I appreciate the opportunity.
Sure.
As far as so the discount applies to the assistant actually paying for the plan. So we assume that the assistant's charging a overall fee for the service, and would incorporate the cost of the My Advocate platform inside of their fee, and they're paying for it at a 40% discount. So they would pay for it directly and then collect the money from the client. If they wanted to, they could use the client's credit card information or with them and actually process it at that discount rate, depending on how they want to charge for their services. So you either can mark up the services to our retail price and keep that margin in addition to your fee, or extend the discount to your client and simply charge your fee on top of that.
Okay, can it be used for out-of-state business?
So we support all 51 jurisdictions. That's 50 states plus DC. DC, of course, has their own statutes for estate planning, and so we support all 51 states. And yes, you can. Now, there are you have to be aware of the laws of every state as to what you're able to do as far as assisting someone in their estate planning activities. And California has been probably more advanced than many other states in clarifying that process and having a process, and that's the reason this course exists and the process of certification exists. So, but we do so that you could potentially make this work for well, you could create a plan for any state, and we've designed the documents themselves to work well in every state. So if someone does do it in California and then they move, all other states are the reciprocal support for other documents, as long as they were created natively in the state that the person was a resident of at the time. So if someone does their documents in California, a year from now they move to Montana, and they walk into a hospital or something occurs, those documents are totally legal. Montana will respect every aspect of the documents and execute them as they're stated.
Oh, that's good to know.
Yeah, so they work well. Now, if in Montana you're now a resident of Montana and you want to redo your documents, you should redo them with Montana statutes. So it's basically as long as you created your documents in the state of residency at the time that you did them, they will be honored by another state.
Okay. I have another question. It says, I assume that, and Colleen, correct me if I'm misreading, but it says, I'm assuming what she means is if she refers somebody to you, does the client remain her client using your program? And does she have access to the data regarding contact information, email, and other valued data important for marketing?
Great question. So we have an affiliate program. So if you choose to go with that 20% referral approach, where you simply refer someone, they use a link that you give them, and that link automatically will notify us that and when that customer pays for their plan, we know 20% goes to you and send off money to you because it's been tracked through a special link. And so the client paid for themselves. We track what's paid to you, and we send the money to you. As far as the ownership of the client, they're going to be a My Advocate client. We don't sell their information to anyone else. If in their program the client says, "Hey, I want," you can actually add as a My Advocate client. You can indicate who you want as your advisor, and if they make you the advisor, just key in your email address and add you as an advisor. You instantly have access to their account and can help them and oversee the account and see their documents. So as long as they do that and give you permission, you have full access.
Okay, I have another question. Is My Advocate program only for Advanced Healthcare Directive or for a complete trust document? And then it says, I noticed that it is covering several areas of trust and not just healthcare directives.
Yeah, so we're a complete health estate plan platform. So we do everything from the will to a living trust to general power of attorney and the Advance Healthcare Directive documents. In other states, they have healthcare power of attorneys and living wills as separate documents. But in California, we take care of all those documents for you, and you can choose. So a customer either goes down the path of what we call a custom will plan, where it's a will along with those power of attorney and Advanced Healthcare Directive documents, or they go down a living trust plan, which is a pour over will, a living trust, a certificate of trust document, and then the power of attorney and the Advanced Health Code. So those are the documents that you get when you follow the process and go through the experience at My Advocate.
Okay, I have a question about what does My Advocate charge for an estate plan?
Well, they range from for a single person doing a will will, general durable power of attorney, and healthcare power, the healthcare advance directive, that starts at 149, and it goes all the way to 589 for a couple doing a living trust. So there's a variety of prices in between. If you go to myadvocate.com/pricing, you can see the different prices. We do have a very simplified free version, which is kind of designed for someone with not much complexity in their life, but
Wow.
there is a free product that can kind of get things going. It's probably someone in their 20s, probably it would fit their setup.
That's really
One
reasonable.
thing I wanted to say about the pricing is that My Advocate has gone out of their way to make special pricing available for LDAs in this class. So what he was quoting was more of the standard pricing. So at the end of the video, there was more information about the special offer for LDAs.
And then
Great call out, Rex. Yeah, so basically it's the 149 price minus 40%, and so that's
Wow.
it's a lot. It's very good, great pricing, and thanks to Rex who's kind of organized this. So
That's really reasonable. Someone asked, is there a promotion code for how do they sign up, and do we need a promotion code? I guess just use the email that showed at the end of the video and click on there.
yeah,
and
send us an email. We'll send you the details as to how to sign up and be able to be enrolled for this particular program.
Yeah, let me comment on that also. The way you pick out which services you would like to utilize with My Advocate, and working with them, you figure out you want this service, the other service, and then they will send you a written agreement that formalizes your association with them and specifies in writing what you had been talking about.
Okay, there's actually two questions. They're asking if you have a deed platform and if you do grant deeds.
We don't have a deed platform. However, when you generate the documents for your living trust, we do give a checklist of things to do. And in that checklist, we talk about the fact that you do need to get the most benefit of a living trust. We have a portable will, so if someone doesn't transfer their property still will go through their living trust. It's just going to go through probate. And one of the benefits, huge benefits of a living trust is to avoid probate. And to avoid probate, you need to retitle some of your key assets in the name of the trust. And there's a couple ways to do that. Many people just go to the local county office or their website and you download a free PDF form and fill it out. It's usually 2-3 pages. You get it notarized and they charge you $10 or $20 to file it and you're done. That's got a quick claim deed. So many people do that, but you got to know you got to fill it out, and you got to know, your strap numbers and all those things. Or there's two companies that in the document we provide you as part of the checklist. We recommend two companies that do this online and do a good job. It's kind of a turnkey solution for you. It makes it easier. They're a little bit like My Advocate is to the estate planning documents. They are to deeds, and one is called deedclaim.com, and the other one is called udeed.com. And they charge anywhere from $59 to $300, depending on how much white glove service you want on that property. And so they take care of that for you. So
I have a comment on the deeds. Yes, the program does have a link for two vendors to be able to create the deed. One thing that we have done is we found that in California, the title companies make available a large amount of real estate forms that are adequate for California and specific to California, and they're free and they're fillable. Most of the deeds that we prepare, we get the copy of the prior deed that was recorded, so we know how the title is vested. And we also want to get the prior deed recording because of the attached legal description that you'll have to include in preparation of the deed. But the deed itself, it can be done any way that you decide to do it. And the way we do it, we have a service that we pay for we put in the address, we get the deed back, and then we take the title company, fill in forms, and take care of the rest of it. So it's not that difficult a process, and you don't need any special software to do that other than PDF or Microsoft Word.
Okay, a couple more. I have 2 customers who are wanting the entire trust. Am I understanding you are a one-stop shop for everything?
Yes, you can go, basically, if you walk through the MyAdvocate platform with that customer and ensuring that you understand what their objectives are, it will produce the final signable legal documents for the living trust. It will include a Part 4 of a will, a living trust document, the certificate of trust, and then, of course, the durable power of attorney, as well as the Advance Healthcare Directive. But basically, you'll get all those documents ready to sign. And I mean, I've seen customers do it in under 20 minutes. But typically, if you watch some videos and read some of the help and kind of go back and forth looking at the diagrams, the average time for someone to go through is about 30 to 40 minutes.
And I'd like to comment there. I've gone through it, and it takes about 35 minutes or 45 minutes. But I have a term that I use for when you're asking about an estate plan package, and that's, part of our copyright on the name of our book. My Advocate does a comprehensive estate plan. So you get a trust, a pour over will. If you need an AV trust, they do it. Then you get the power of attorney for financial management, and you get the Advanced Healthcare Directive. And they also provide other additional forms like a certificate of trust. So it is a comprehensive estate plan in the terms that I use.
So somebody wanted to know, Rex, it says that you use ForTrust, and are you using My Advocate, and what's the difference between the 2 programs?
It's just a different function. What we're doing with, first I used California Wills and Trust by LexisNexis that Colleen Marie uses or used to, and then we got into ForTrust, and they have an online version called Adapt. And what we are most interested in with My Advocate is the service where we refer a customer to My Advocate, and then the client goes through and does the interview on their own, and they're not having advisory services. So what we want to do is the clients that we have started in our office, they filled out our client organizer. We will continue to do them more than likely on ForTrust. For clients who perhaps we could have a different price structure or something where maybe they don't want to pay our fee for a comprehensive estate planning, then we're happy to refer them to the self-help version of the software.
Okay, so the pricing is wholesale, and so we could charge the client whatever we want, and we could go in and complete the documents on your program.
Yeah, you're buying them at a discount from the retail price, and you can charge whatever you'd like. You can charge our retail price and make a 40% margin, or you could charge more. There's nothing holding you back from charging whatever you'd like, and you should get paid for your service, your time and your energy and the process that you're going through. So then the customer should respect that, of course, too. So everyone runs their business differently and kind of determines how they present their value and how the customer perceives the value. So there's no
Sounds pretty good.
there's no constraints on how you can charge for the services.
And I would like to make the commentary that there may be a lot of other cost, features, markup questions that I think probably ought to not be here in this format.
Right.
Work directly with my advocate, ask your questions directly, and they'll be happy to provide the answers to you.
And Colleen did say she does still use Matthew Bender. I use it too. We both use it for a long time. So we're hitting, well, 7:30. I think we need to, I don't have any more questions. So I think we need to kind of wrap up. Is there anything you want to finish off with, Rex?
Yes, I wanted to finish off with a philosopher's view from a famous philosopher named Stephen Perry, and I'll close off because it has to do with, I think that we can conclude.
Thank you, Mr. Wolfs, for presenting here in our class tonight.
Yeah, thank you, Rudy, for being on with us tonight.
And we'll see you all
Great.
next month.
Thank you.
Okay, very good. So we'll conclude for now, and I hope everyone found this to be informative. Bye now.
Thanks, Rex. Good night.
Bye.